Ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only. I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no one that I've hurt. Objection hearsay. Objection hearsay. I'm not a sovereign citizen.
All right, buckle up. So this man gets pulled over doing 92 in a 75 on the Kansas Turnpike. And instead of just handling the ticket like a...
Mr. Robinson, are you here?
I am here representing the name, ma'am.
All right, you need to start your video, please. And you are, is it Tremaine or Tremaine?
The name I'm representing is Tremaine.
Tremaine. And how do you pronounce your middle name?
J.
Tremaine J. Robinson.
On and for the record, ma'am, I want to say that I want to give notice to reserve all my rights and inform the court that I'm not here to testify or plead. I'm here to make a special appearance to challenge the jurisdiction only.
All right, anything else?
Yes, I would like to see evidence of a charging instrument.
Were you not given a copy of the ticket issued by Trooper Collins?
The charging instrument that I am referring to is a sworn affidavit of the client, of the person that I've hurt.
Now, this is a speeding ticket alleging that you did on March 27, 2023 at 8:48 a.m. operate a motor vehicle in Butler County, Kansas at the speed of 92 miles per hour when the posted maximum speed limit was 75 miles per hour. So this would have been out on the Kansas Turnpike, Highway I-35. Now, what else were you wanting to know, sir, as the allegations against you?
I would like to see evidence of the affidavit of the people that I've hurt. This is a victimless crime if there's no
normal adult. He shows up to court with what I can only describe as a 7-page "I found this on the Internet" legal manifesto. He starts off calm, real calm.
Well, the victim would be the state of Kansas in that you violated the laws enacted to protect the people of the state of Kansas. But this is not the type of crime which would require or have individual names listed. So your next point, if any?
My next point is, as I stated, ma'am, I'm not here to testify. I'm not here to plead. I would like to see the affidavit with 2 signatures for the person that I've hurt. If I didn't hurt anybody, there's no crime.
All right, well, I'm going to proceed. The subpoena was issued July 7, 2023 for Trooper Collins. Then on July 31st came a correspondence from the defendant as referred to by Mr. Regier herein. Looks like it's about 7 typed pages, and as counsel said, it's entitled Challenge for Jurisdiction and addressed to Butler County District Court Clerk, Butler County District Court Clerk, Office of the Attorney General Derek Schmidt. And it mentions subtitles under the following case law. I request case 2023 TR 1193 be dismissed. Pretty much standard language that is used by folks who call themselves or are considered sovereign citizens. Quote, it is on this date, July 27, 2023, I, Tremaine J. Robinson, it's Tremaine-J, Robinson, in the county of the Seminole of the state of Florida and a zip code, a natural man, attorney in fact, as a living human being who's the beneficiary of Tremaine J. Robinson trademark. Swear that the information in my sworn statement is truthful to the best of my knowledge and understanding. I, Tremaine J. Robinson, beneficiary of Tremaine J. Robinson, revoke my signature on any and all pages of any and all tickets, summonses, contracts, and/or agreements signed by the side of the road in the state of Kansas by Officer Collins K. And so here we are. Now, Mr. Robinson, normally I would be upset that you filed what appears to be in part a motion for discovery, and you didn't get that. However, you did not address that document to anybody but Butler County District Court Clerk, Traffic Court, Butler County District Court Traffic Clerk. You sent one to a P.O. box in Topeka, and then you sent a copy of it to the Attorney General. But you did not send it to the Butler County Attorney. Therefore, he did not know you were trying to get discovery.
Ma'am, I do have a tracking number that says it was delivered at the Butler Attorney.
Okay, well, that's not on file. What you want to present that at this time?
Yeah, someone signed for it yesterday.
Ma'am, I reserve all my rights. I'm not here to plead. I'm here to challenge jurisdiction. Okay, here we go. Then he drops the classic line, I would like...
And this document that I'm giving the benefit of, it's a multi-subject document, but this document filed by the defendant that I'm giving the benefit of including what he offers as a motion for discovery was not filed with the clerk until July 31st. So that was after the statutorily required 21 days. And then it was not filed upon the prosecutor who would have, or the witness who would have held any evidence, but rather again on Butler County Clerk in Topeka, Kansas, that to my knowledge doesn't exist, the Butler County Clerk in El Dorado, and Attorney General then Derek Schmidt in Topeka. And that's if it was served, if I take the defendant's benefit of the doubt, that it was saying it was served sometime yesterday before today's 1:30 trial, the court has to decide if that later time was reasonable. And I do not find that it was reasonably served on the county attorney. I am at this point going to say that any last minute motion for discovery is denied and we are prepared to go to trial. Now I've lost you, Mr. Robinson. Are you still somewhere available?
No.
What are you doing there with your computer?
Right now, I was looking for a document, but no, I am not available for trial. To see the affidavit of the person I've hurt. This is a victimless crime. Sir, you were driving 92 miles an hour. Traffic law isn't about waiting.
We're going to proceed with trial. So please put yourself back in front of the camera. Follow the court's order or you could be found in contempt. I don't want to do that. Thank you, sir.
Your Honor, in that particular case involved a sovereign citizen where the court noted in the memorandum opinion.
Objection, hearsay. Objection, hearsay.
Case law is not considered hearsay or.
I'm not a sovereign citizen.
All right, he's not a sovereign citizen. Go ahead, Mr. Regier.
Yes, Your Honor. In that case, the Kansas Court of Appeals noted, quote, the defendant thinks the law does not apply to him. He avows that he, unlike other citizens, is sovereign and immune from prosecution. The court went on to address the issue of venue, which the court noted that, quote, venue is generally proper in the county where the crime was committed. I will address that momentarily, as well as referring to KSA 22-2602. Additionally, and perhaps most relevant to this court, the defendant in that case, quote, complains that his objections to the trial court's jurisdiction to prosecute him arise from the claim that he is a sovereign citizen. This is not the first appellate court to deal with such a claim. Another panel of this court used analysis of federal case law to reject a similar claim. And then quoting from Seventh Circuit and Eighth Circuit cases, quote, an individual's belief that his status as a sovereign citizen puts him beyond the jurisdiction of the courts has no conceivable validity in American law, regardless of an individual's claimed status of descent, be it as a sovereign citizen, a secured party creditor, or a flesh and blood human being. That person is not beyond the jurisdiction of the courts. These theories should be rejected summarily, however they are presented. And with that, I would respectfully call my first witness to the stand.
All right. I do find that this court has jurisdiction and venue to proceed, and the arguments made by the defendant in the 7-page document referred to previously are summarily dismissed.
Waiting for someone to get hurt. It's about preventing it. The judge explains it clearly. The state is the victim because the law was violated. That's how this works. But he keeps going.
And did you ultimately write the defendant a citation for speeding?
Yes, I did.
Or an annual redirect? No further questions.
All right, Mr. Robinson, this is your opportunity to cross-examine the trooper. You can question him about his testimony. It's not quite time for you to give your own testimony, so these addresses to the trooper have to be in the form of question. You don't have to question him, but you can. Would you like to?
No.
All right. Mr. Regier, any further evidence?
None from the state, Your Honor.
The state rests then, Mr. Regier?
The state does so rest, Your Honor.
Mr. Robinson, the state rests. They have presented all the evidence they intend to. Would you like to present any evidence? Again, you don't have to. Your silence will not be used as a sign of guilt. But if you'd like the court to consider your position, I'd be happy to do so.
I don't understand.
Well, do you want to tell the court your version of what happened?
No.
All right. You don't wish to present any evidence then. Am I understanding you correctly?
The evidence that I tried to present, you won't give due process.
Okay. But do you want to give any testimony about the events leading up to this ticket, March 27, 2023?
No.
All right. Well, I will find the defendant guilty of speeding 92 and a 75. The scheduled fine is $87. Court costs are $108. The total due will be $195. Sir, you do have the right to appeal this proceeding. You can appeal it to the Kansas Court of Appeals. You have up to 14 days to file that notice of appeal. Your appeal bond will be in cash, the same as what your court costs and fines are. That's $195. Can you have this paid, this fine and cost paid in 14 days, or do you need some time?
Revoking signatures. Claiming he's a natural man. Sending discovery requests to the wrong offices. Mailing documents basically the day before trial and acting shocked when it doesn't delay the case. And the wild part. He insists repeatedly, "I'm not a sovereign citizen." Meanwhile, the prosecutor calmly reads appellate case law that says very plainly these arguments have no validity in American law. The judge doesn't blink. She dismisses the 7-page document in about 10 seconds. Then comes his moment. The trooper testifies. The state rests. The judge gives him a real opportunity. Do you want to present evidence? Do you want to testify? And he says, no. That was it. That was his shot. Guilty. $87 fine. $108 in court costs. Total, $195. All that paperwork, all that performance, all that confidence, for a speeding ticket under $200. Look, you can disagree with laws. You can challenge things properly. But walking into court armed with internet slogans and refusing to actually participate? That's not strategy. That's self-sabotage. And the hardest part to watch. He genuinely seemed to believe this would work.